stark difference between those who have embraced education and those who have shunned it is quite clear.
Having taught constitutional law
From
for many years,
industrialization,
talking about
environmental
public participation
conservation,
means we are talking
education
about
shapes the
our
future.
sovereignty.
And today,
And
in the
based
face
off
of climate
Article 1,
change,
that would
Kenya's
dictate
children
that all
are
sovereign
leading
power
the charge,
belongs
proving
to
that
us
even the
as the
youngest
people of
among
this
us
country,
can be
then
powerful
it is high
agents
time
of
that we
change.
talk about these strategic lawsuits against public
In Kenya,
participation, the
where
very
climate change has
pinnacle
brought
of
prolonged
our sovereignty,
drought,
because without
erratic
public
rainfall,
participation, then it
and
means
devastating
we do not
floods,
have a say,
the
we do not
fight
have
for a
access to
sustainable
justice.
future
So now,
is more
talking
urgent
about
than ever.
the rule of law and how it intersects with SLAP litigation,
Amidst these
when I
challenges,
think about
hope
principles
is growing,
underpinning the
literally
rule of law,
from the ground
first in
up.
line we have to talk about equality before the law, which of
Schools
course
across
we
the
are all
country
equal
are
before the law. In
becoming
fact,
hubs of
Article
climate
159
action,
would
where
talk
children
about
are not
this
just
in the sense that
learning
we
about
can
the
all
environment,
access
but
justice.
actively
It will also
shaping
talk
it.
about the supremacy of the law, that indeed we are talking about the Constitution, it allowing us to discuss matters public participation, and thirdly, and most importantly, the independence of the judiciary, which is key when it comes to the strategic lawsuits against public participation. Now, in us now looking at how it intersects, apart from those principles, equality, independence of the judiciary, and the supremacy of our law, it is important for us to talk about defamation in the case of strategic lawsuits against public participation, which we have seen. We have also seen injurious falsehoods in the sense of bringing litigation that would not really stand in terms of questioning the issue of public participation and our access and
Those
our
called
right to express
environmental
ourselves.
children
We're
like
also talking
Mwende
about
are
vexatious
learning about the
lawsuits, which we
impacts
have
of climate
seen,
change
and of
how
course,
to
looking at
combat
the
them.
independence of the judiciary
These clubs
under the
provide
rule
a
of law.
space for
We
hands-on
must
learning,
accept, we
where
must
students gain
remember
practical
that
skills in
indeed
tree
these
planting,
lawsuits
water
must
conservation,
not
and
delay justice,
biodiversity
must not be
protection.
seen to delay justice,
During my visit
must
to these
not be
schools,
seen to
I've
be
seen something
vexatious
truly
in the sense of
remarkable.
our
The
morality
children
as
don't
well
just plant
as
trees,
the rule of
they
law.
take
So that is the
ownership of
intersect
them.
between these principles to access justice and
They
Article
care for them,
48 and the
nurture
rule
them,
of law in
and
terms of the
watch
three
them
principles
grow.
that I've mentioned
These trees
and
are
how they
not just
intersect
about the
with the
environment.
strategic
They're about
litigation
empowering children
against
to
public
believe in their
participation.
ability
Thank you
to
so much,
create
Ms.
change.
Catherine. Moving on to our next question, which will be answered by Mr.
The
Martin.
results speak for themselves.
One of the
In just a
specific
few years,
taglines of the
Bank
13th edition
Societies
All Kenyan
have
Multi-Code
planted over
competition is
55,000
data protection in
tree
national
seedlings
security.
and distributed
What we saw in the
100,000
Finance
seed
Bill
balls,
2024
survival rates exceeding
protests last year,
65%.
where data was really misused.
But the
Even
impact
looking
goes
at
beyond
members of
numbers.
parliament,
These
their
children
numbers
are
being
growing up
accessed.
with a deep
But today we are
understanding
focusing
of their
on
role in
specifically
protecting the
activists
planet,
and human
and their
rights
actions
defenders.
are
And so
inspiring their
given the
communities
increase
to join the movement.
in the use of slaps to suppress dissent and the potential misuse of
ripple
personal
effect of
data,
these
can
efforts
Kenya's
is
current
undeniable.
legal and
As
regulatory
children take
frameworks
lead, they are
inadvertently
bringing
enable powerful entities to stifle
They are bringing
democratic
their
freedoms
families,
and civic
neighbors,
public
and entire
participation?
communities along with them. Together,
Thank you for
they
that
are building
question.
a more
First and
resilient
foremost,
Kenya, one
I'm
tree
greatly honored
at
to
a
be
time.
before you here to participate as a panelist.
It's a
And let me
testament to
dive
the
right into your
power of
question. I
education,
think
the
the current
resilience
legal
of
framework in
children,
Kenya has
and
created
the
a conducive
hope
environment,
that even in the face of
for
climate
big
change,
corporates
a
or even
brighter
powerful
future
entities
is
to actually
possible.
institute
And
slap
this
suits against
And as
human
these
rights
young
defenders or even civil
environmental
society
stewards
organizations
grow,
or voices
so
of
too
defense.
will
And
the
that is
forests
primarily
they have
because
planted,
when you look
tall
at
as a
Article
living
22 of the
legacy
Constitution of
for
Kenya,
generations
it provides,
to come.
it gives leeway
Because
to
when it
any
comes to
litigant. If you
climate
feel your
change,
rights have
the
been
smallest
infringed, then it
hands
gives you
can
leeway
hold
to actually
the
institute a
biggest
suit.
solutions.
And that is what many of, and that is what many movers of slap suits, just like any other innocent litigants who feel that their rights have been violated, have used to actually institute suits against human rights defenders. Now, coincidentally, maybe most of you or some of you may not know is that most of these slap suits are usually, or the agents or the persons behind the slap suits usually take the top farms in town. because they have the money to pay most of these firms. So you find that they hire the best lawyers on the market, and most of the human rights defenders or even civil society organizations cannot afford, the top tier firms in Kenya, and that is why it's been used to great effect, to stifle their right to freely express themselves. So as is, the current legal framework actually creates a conducive environment, and that brings me to the second segment of your question, which is to do with, what radical reforms do we need to, pursue. I think the first one is we need to come up with a legal framework around anti-SLAPP suits. There needs to be a higher threshold when it comes to entertaining SLAPP suits, because as is right now, cases are hard on their merits. So parties present their pleadings before a court, and your case will be determined on on its merits. I also think the judiciary needs to, raise the standard on what issues they need to be determined between the disputing parties, specifically if it's a SLAPP suit. The other third radical measure that I would propose is the issue of weaponization of investigative and oversight agencies. Kenya has a broad host of investigative and oversight agencies that are meant to serve Kenyans. But what we've seen in the recent past is that entities like the Directorate of Public Prosecution are used by the state or powerful people to they're actually weaponized. And when you speak against a powerful person, then that is when KRA or the DCI summons you or tells you have tax issues. So we need to reclaim the independence of these investigative agencies. And then we also need to borrow heavily from progressive jurisprudence that has been decided in other jurisdictions and how they have dealt with SLAPP suits. And lastly, two issues. One, the issue of the security deposit that is always placed on the parties. In most instances, when you're served with a SLAPP suit and court requires you to deposit a security of some sort, you realize that most human rights defenders or even civil society organizations cannot afford these hefty sums of money. So I think courts should actually review these figures, because they're extremely high and they actually work to the detriment of human rights defenders and citizens. And then lastly, on the issue of dispensing SLAPP cases, for the longest time, our judiciary has been bedeviled with case backlog, and different chief justices keep saying how they come up with progressive reforms on how to deal with the issue of backlog, but it's still a lived reality. So it is something, we should be able to entertain SLAPP suits in the quickest time as possible, such that human rights defenders or the rest of Kenyans can be able to enjoy their fundamental rights. Thank you.
Thank you so much, Mr. Martin. Now, moving on to Mr. Joel. Mr. Joel, we've seen your executive director for Amnesty International Kenya recently in an interview, very vocal about questioning the government's accountability even in what happened in last year's protest. And with the rise of digital governance, SLAPPs are now extending into cyberspace, where personal data is being weaponized to intimidate dissenters. And so, has the misuse of personal data been leveraged in SLAPP cases to intimidate and silence dissent in Kenya? And what legal and regulatory frameworks exist to protect personal data, and how effective are they in preventing such misuse?
Okay, thank you for that question. And I must appreciate the opportunity to sit here in this panel. This is the first time I'm sitting on a panel. And back to your question, I must agree that, especially during the 2024 Gen Z protest, that personal data was used to launch the SLAPP suits in this country. And you'll find that even during the beginning of this year, that Safaricom was accused of aiding the government to mine personal data so that people could be abducted, and at the end of the day, most of them were taken to court. And personal data is protected by international laws, various international laws, but coming into the Kenyan context, you come to realize that Article 31 of the Constitution speaks on the right to privacy, that you have the right not to have your personal information being interfered with without your consent. And building from Article 31 of the Constitution, Kenya enacted the Data Protection Act of 2019, which defines what means, it all entails to mean with the personal data, personal sensitive data. And from this is some of the Data Protection Act is one of the legislations that have at least breathed life to Article 31 of the Constitution. And you also agree with me on the Computer Misuse and Cybercrimes Act that was enacted in 2018. And this one will now lead me to whether these laws have been effective. And I must say they have not been effective because you will realize in 2017 the High Court declared Section 194 of the Penal Code to be unconstitutional because it allowed the decriminalization of the defamation. But you see, a year later, or less than a year later, the Parliament enacts the Computer Misuse and Cybercrimes Act, providing for a criminalization of some of these online activities, that is sections 22 to 23. And in response to your question, you will find that these sections can be broadly interpreted by the powerful entities to criminalize those people who criticize the government and even who are political dissent in the country. Thank you.
Thank you so much, Mr. Joel. Now, Ms. Sylvia, to add on what Mr. Joel has said, he has mentioned the Computer Misuse and Cybercrimes Act. So, does this act enable or constrain the use of data-driven slaps to silent dissent? And what reforms could address potential misuse?
Okay, thank you very much. I just want to say thank you so much for inviting me to this panel. It's been several years since I was on that side of the room, and it's nice to always see young budding lawyers listening and participating in these legal, competitions. So, in terms of the legal framework in Kenya that has supported all that we've had so far, there are several laws in Kenya currently. If you think about it, you can think of the Penal Code. Joel has just mentioned the Computer Misuse and Cybercrimes Act. There's also the Defamation Act itself. There's the Books and Newspaper Act. There's also the Preservation of Public Security Act, Prevention of Terrorism Act, and of course with the Security Laws Amendment in 2014, there was also an element of that. But I'll just focus on three. I'll first start with the Defamation Act. If you look between Section 3 to Section 5, it defines slander and provides for slander in different forms. There's slander against official business, professional business, even against women when it relates to chastity. And these sort of sections have been used towards promoting SLAP legislation, not just legislation, but the jurisprudence in courts. And this has been seen severally because if you also look at the Defamation Act, it provides a minimum cap of, I think, 1 million Kenyan shillings that the High Court can use as damages. And just to also clarify, the Defamation Act does not provide for you to prove special damage in your claim. So that leaves the door wide open for businesses, for corporates, for whoever to just misuse this law against activists, against human rights defenders, against civil society organizations, actually. And I think from 2000, there was a case, Nicholas B. Watt, against Clayworks Limited. And in that case, he was awarded a lot of money. I can't quite remember how much it was. But since then, the courts have been very, I'd say, progressive and in the wrong way. Very liberal in terms of handing out large amounts of money in SLAP suits. So that has gone badly. We also have the Penal Code. If you look at Section 41, it provides for treason. It provides for not thinking about the death of the president or imaginations about such things. And you can see that this has been used recently for cartoonists and activists and people who've been doing such things. So that's also another way. And then lastly, as Joel has just talked very extensively about, is the Computer Misuse and Cybercrimes Act, Section 23, Section 24, regarding publication of false information knowingly. Such sections have been used, but again, as he mentioned, the High Court has ruled that criminal defamation is unconstitutional, but still Parliament went ahead to just publish this, to pass this law. And so this legal framework is what we exist in, which allows for SLAP to thrive, which allows for SLAP to be used against activists, against human rights defenders, even normal citizens, just to threaten them, to derail them, to ensure that they use their time and their resources in the courts, as opposed to doing the work of holding government accountable, holding corporates accountable, And so what do we have in the end? We have a situation where a person feels frustrated, scared even because of the kind of threats they receive. And for women human rights defenders, it's even worse. And you'll see from some of the studies that Nzalendo Trust has released regarding SLAP. We've released 2 reports on this so far. And you can see that then what needs to happen, as you've asked, what reforms could we say? I think most of it has also been mentioned. We need to incorporate anti-SLAP legislative and legal frameworks into already what we have, and that could be a standalone act on its own, or several amendments to the acts that I've already mentioned. There's also need for just ensuring that we provide support to those who undergo this, whether it's civil society, whether it's the activists and human rights defenders, and so perhaps a defense fund, a legal aid fund for this sort of people would be best. And then lastly, it's just collaboration with media, with these partners, just to be able to see how best you can be able to plug in and assist them would be the first step towards this. But the fact that we are having this conversation already shows that we have acknowledged there's a problem, and so there's a lot that needs to be done.
Thank you so much. Press the right to demonstrate in Kenya, and how does the Public Order Act and other related legislations address this issue? And afterwards, after you answer your question, Ms. Patricia, I'd like now Ms. Anne Gitonga to talk about measures that we can take as a country to ensure that the right to demonstrate is protected from the misuse of SLAPs. Thank you.
Thank you. Thank you very much for having us. We are very happy to be part of this moot court competition for this long-standing partnership in this engagement. And I'm also grateful that these questions that we are discussing today are quite relevant to the situation in Kenya. When we talk about SLAP suits, we don't talk about it in the vacuum. We are looking at it in the context of where are we in Kenya, and when there is autocratic tendencies or repressive practices, especially from public officials, then we continue to see this threat as increasing. And maybe my starting point in that regard is always in the issue of the right to demonstrate as protected by Article 37 of the Constitution. And this right is not just to demonstrate, it also includes the right to picket, the right to present petitions, and of course the requirement there is that it should be peaceful and not armed. We have seen currently, even before June 2024, when there was an increase in the public protests, we have already seen the tendency of criminalization of public protest. It is a constitutionally guaranteed right, but in practice it is one of the most violated rights, because any time people try to protest for any issue, the public security and forces are unleashed on the public, and therefore almost becomes impossible to really enjoy these rights. And we see this in different contexts. There was protests on high cost of living, protests by different labor unions. All the time, that has always been curbed by the police. And when we talk about what does the law does, I think the only legal protection that we can say is dependable is the Constitution, because not only does it guarantee the right, it also sets out instances when a right can be limited. Therefore, any other law, including the Public Order Act and any other laws that are enacted, should meet that standard of limitation. But when you look at laws like the Public Order Act, in fact, they do not protect the right. They actually derogate from the constitutional right. And I could give a few examples. In the Act, the Public Order Act, it requires prior notification. But if you look at how the Constitution gives us this right, your right should not be limited by simply authorization. Why is this wrong? Because once you give the authorization, the notice to the police, the police officer in that region, we have seen what they do. Sometimes they'll tell you, oh, there has been another meeting that has been scheduled in the same venue that you want to use. Or they might say, oh, there is a threat to public security. That is not the limitation that the Constitution foresees. And therefore, for us, that is a threat that is ongoing. Remember, this act is a colonial act. It was enacted way before the Constitution came into place. And if we were to align the spirit of the Constitution and the act, it actually fails to meet the test. If you look at other laws, again, we have the Penal Code, for instance. again, it has been mentioned, but in the context of expression and public, the right to demonstrate, we also see it being an impediment to enjoying the right. For instance, I think and this is what we've been seeing happening when people are arrested when they go to protest. They are charged in court with, for instance, and being engaged in an unlawful assembly. What is an unlawful assembly? We see it being quite misused to deny the right. The same penal code had provisions such as the offense of subversion. And if you look at subversion, the way it was set out in the law, it is actions or words that have a subversive intent. If you go again to look at what is a subversive intent under the penal code, it's such a broad spectrum of acts and words that threaten public order and public security. But thankfully, through a suit by Katiba Institute and other partners, that provision was declared unconstitutional. I think even another issue we see is how this expression and public right to demonstrate is diminished through weaponization of other laws. And there is an intersection even in this respect with what has already been spoken about surveillance, even in the context of offline and public surveillance. Whenever people would go to the public arena to demonstrate, and especially on the June 25th, what happened afterwards? People were arrested, others were disappeared, and others there were people who were killed. Meaning that even when this right to demonstrate, in practice we are not enjoying it, and laws are being weaponized to curtail people's ability to participate effectively and without fear. And now this takes also me to the question of then what measures can we do to ensure these rights are protected? I've mentioned one of them. We have many repressive provisions in statutes that we need to continually challenge through either public interest litigation or strategic litigation, or simply push back when you are taken in court. For instance, we had criminal defamation that was declared unconstitutional through the law, through a case in court. The same way subversion was declared unconstitutional. That needs to lead to actual legal reforms, but in practice that has not been done. Secondly, not only, and this also goes to even our collaboration with institutions like judiciary, we need to push back against legitimizing cases in court that emanate or that are premised on violation of human rights. For instance, if someone is disappeared, or in this case abducted, because it's not a legal arrest needs to be done in the open during the day. There is a summons, there's a record somewhere of the police station where you're being taken, there's an OB record of that arrest, there's presentation in court before 24 hours. But you see, all those access to justice provisions tend to be violated. So if they are violated and then someone is presented in court, should courts legitimize such prosecutions? No, because they already emanated from violation of human rights. Again, I think we all know that slap suits do not, sometimes you may think it's a legitimate suit because this comes disguised as a suit that pursues a certain action, but when you look closer, you can see the intention behind it is to prevent, is to curtail expression or silence critics or academia, media, and even civil society. So it means there's a capacity that needs to be done for judiciary for them to identify this is a slap suit whose merit is actually is not a legal merit and is an abuse of the court process. And then, of course, when we get legal reforms, this would include enhancing protection for the rights. For instance, we need a robust public participation law, which is not yet there. Such legal reforms are necessary for us to continue enjoying expression and the right to demonstrate as protected by the Constitution. Thank you.
Thank you so much, Ms. Patricia. Now, Ms. Anne, as you add on more measures or reforms we can introduce, I would also like you to speak about how this phenomenon of slap litigation affects human rights, and painting the picture on how it affects democratic values, human dignity, and also the issue of social justice in our country.
Thank you for that question. I'll just start by saying that the framers of the Constitution were very aware that we are likely to have a government that is strong, that needs to be put in check, and we were it also anticipated that we would have a citizenry that needs to participate in governance. And so all those areas have been well protected by the Constitution. And especially the right to demonstrate, as my colleagues have said, is well protected under the Bill of Rights, Article 37. We have our national values under Article 10 that talk about many things, including the right to participate and take part in governance of the country. So the protection of the right to demonstrate was not there for a mistake. It was there to protect citizens who seek to engage in governance, but then they are countered by very strong governments that, such as ours, that curtail these freedoms. And the right to demonstrate is only limited under very special circumstances. So the question is, what can we do to ensure that this right is protected from the use of slaps? I think we all must remain vigilant and safeguard our constitutional rights. It looks like it's a very noble thing today to do when they say, when slaps are brought forward and cite national security, this person is a threat to national security. It's for us to be vigilant to see what really amounts to national security, what is curtailing a freedom such as the right to participate, the right to demonstrate. So as Kenyans, we must really remain woke and safeguard and protect our rights under the Constitution. We can also counter slaps through PIL, strategic public interest litigation, because PIL comes in also to support, to safeguard constitutional principles. So strategic impact litigation would be one of the ways that civil society can bring forward to safeguard citizens' right to protest and ensure that the judiciary is also making pronouncements against such limitations. But even speaking of the judiciary, continuous training and engagement of the judiciary is key so that they can look at cases, they can look at slaps as a threat to the Constitution that they seek to safeguard. So close attention and close engagement with the judiciary, especially the Constitutional Court. I also see a role being played by the media to amplify voices of people who are helpless, who have been arrested, who have been given cases, or whose cases have been brought against them and they're helpless. So that media advocacy, I see it as something that we can take on as non-state actors. But families of people who had cases brought against them are sometimes helpless. And one thing that we can do to support some of the families is either provide legal support, and the Law Society of Kenya is already offering a lot of support, especially following the June 2024 demonstration. We've seen the Law Society of Kenya coming out to provide legal support to persons who have been affected by cases. But beyond that, there's psychosocial support and maybe trauma-informed care that continues to be given to families by certain institutions that I can even see some of them here, offering trauma-informed support to families whose kins have either been arrested or have cases brought against them. But beyond that, let's document most of these cases that are coming forward. But it's a collective responsibility for us to safeguard the Constitution and protect what we have as rights to demonstrate, to participate in governance, and which can only be limited under very special circumstances. The second set of the question was, are they affecting human rights? They are. Slaps really slow down, claw back on gains that have already been made with regard to human rights protection. And so you find people not willing to participate, you find people not willing to talk against government because they're afraid of what may come against them. So it really takes back what is enshrined by the Bill of Rights of the Constitution. It takes back the human rights participation. It takes back human dignity. And it even takes back the freedom to associate or even to take part in the governance affairs of the country. So indeed, there are many ways that we can, as citizens, safeguard our rights under the Constitution, because they only come to claw back what has already been gained in regard to constitutional protections of human rights. Yeah.
Thank you so much, Ms. Anne. Now, I want us to move to another segment on the role of the media and civil society organizations, in resisting slaps. Now, a good number of our partners, as you can look around, are civil society organizations. And I think we are privileged to have supporting such initiatives, people handling live cases with regards to constitutional matters. If you've done constitutional law, you are aware that some of the cases that Ms. Catherine usually refers to, we've had cases from Katiba Institute and other civil society organizations. And so I want us to talk about the role of these media and civil society organizations and what role they play in suppressing strategic litigations against public participation. And my first question will go to, this question will be answered by Ms. Sylvia as well as Mr. Joel. So how can the media and civil society organizations collaborate to resist and expose slaps that threaten freedom of expression, and how have these lawsuits impacted journalists and human rights defenders in Kenya? I can start with Ms. Sylvia, then Mr. Joel.
Okay. So I think many of those things have been said, many of the actions we can take as civil society organizations and also as the media, but maybe just to emphasize a few. First would be to raise awareness. And this can be two ways. First, document. Each time there's a human rights violation, each time perhaps there's a slap suit, we have to raise awareness that people should know this is happening, this is going on, and the media can play that part. And for civil society organizations, then on the other end, is to provide support to those who are facing these slap suits. This could be through providing legal defense. This could be through providing a support system. There are support networks for people who are activists and human rights defenders who are undergoing this. So it's to ensure that people join this as well. And then also taking research on these issues. And I think, like I've said, this is a growing concern, and we've seen it since June 25th. And so just as much as we document, we also undertake research. So continuous legal analysis, continuous legislative review. Currently in Parliament, we are seeing this, the Assembly and Demonstrations Bill that's on the floor of the House. So how then do we review this? How then can media engage with this bill and civil societies as well? For the media, they have different groups, I'd say the Media Council as a regulator, but there are also caucuses that they have within themselves. And a key one is the Kenya Parliamentary Journalists Association, which would be very relevant towards engaging Parliament and submitting memoranda on this particular bill. And of course, narrative creation. That is the role of the media. How does the media form, create, and foment narratives about SLAP to the public to ensure that not only does the public understand, but the public also provides support towards persons who are facing this. As has also been mentioned severally, strategic litigation, public interest litigation is very necessary, very important, and for us to also support organizations that do a lot of this work. And I know Katiba Institute leads a lot of this work on this matter. And then, of course, as has also been mentioned, engaging the judiciary, just to be able to train judiciary officials and judges, magistrates, on the law, on new international human rights standards, on what we can be able to adopt. Because as we all know, case law forms part of law, forms law actually. And so it is the duty of judges to quickly identify this is a SLAP suit disguised as a commercial interest suit or whatever suit, a defamation lawsuit, and just to be able to ensure that these punitive damages do not come to activists, human rights defenders, and civil society organizations.
Over to you, Mr. Joel.
Okay, thank you for that. But maybe just to add on collaboration between civil society organizations and the media is on embracing now engaging the citizens in the sense that we need to go back to the citizens and hear what they have to say about these SLAP suits, and their information and their feedback will be crucial in making recommendations to the parliament. And also maybe another collaboration is the sense that we need to petition to the parliament, presenting petitions on the negative impact that these SLAP suits are having on our citizens and maybe the online activists. And finally, maybe to call out these powerful entities and also initiate suits in the courts of law so that the cases can be dismissed at an early stage. You look at the cases of mineral search in South Africa, where media and civil society organizations were able to call out for a mining organization that intended to extort an activist who was maybe who was exposing wrongdoing from the organization. And also in research, that is a desktop research, active civil society organizations and media will publish this information. And actually, as in doing so, you'll be expressing the academic freedom that is there for academic writers. And the European University case, you'll find that the European Court of Human Rights was categorical that academic writers have the freedom to expose all the wrongdoing from the findings of their research. And maybe to turn on to the second bit of the question is on the impact that slap suits have had on the freedom of expression. And maybe I'll mention that it creates a culture of fear, which in turn that the activists, civil society organizations, human rights defenders, journalists, they fear exposing the wrongdoings of the government and other powerful entities. And this actually will defeat the theory of Article 19 of the ICCPR. Another thing that it does is